As a whole, our group firmly believes that the absence of emotional distress damages in normal negligence cases, as well as the requirement for publication to more than one person for liability in invasion of privacy cases, are both based on legal principles aimed at balancing the interests of individuals and society as a whole, while also taking into account practical considerations and legal liability limits. Classic negligence lawsuits aim to compensate for tangible losses like bodily injuries or property damage. Emotional suffering, while meaningful, is challenging to quantify and validate. Courts are and should be cautious to award damages for mental distress alone unless it's accompanied by bodily harm or property loss. Allowing emotional damages in every negligence case may lead to numerous claims, potentially ill-founded or inflated, burdening the judicial system and defendants raising insurance premiums and discouraging socially beneficial activity. For these reasons, we completely support the Indiana Supreme Court's decision that a person cannot obtain emotional distress damages in negligence theory in instances involving the revelation of private material to the public. Invasion of privacy is a crucial legal concept that aims to protect people's rights to privacy from unwarranted interference. It includes the release of private information which can harm an individual's reputation, dignity, and even emotional well-being. Requiring publication to multiple parties in privacy cases serves multiple purposes, such as distinguishing between private matters reserving legal protection and those of public interest. It also ensures that privacy violations are adequately proven and prevents unfair limitations on communication and expression. Because of these examples, our group also supports the requirement that dissemination to only one individual is insufficient to show the dissemination to the public aspect in all invasion of privacy theory scenarios.
Going to be discussing one of the main arguments on why this proposed law should be supported. So this law will impact healthcare professionals, patients, policymakers, and healthcare facilities. When it comes to our personal health information, privacy is a must. It's not just about keeping our medical records under lock and key, but it's also about safeguarding our dignity and our autonomy and our trust in our healthcare system. Why is privacy protection important? Well, it's about respecting individuals' rights over their own medical information. It means that medical providers cannot release or disseminate our personal health information without authorization. What happens if our privacy is violated? We should have the right to seek compensation for any damages incurred. However, emotional distress is complicated because it cannot necessarily be measured. It is easy for individuals to lie about their emotional distress in hope of a monetary reward. On the court side, it is difficult to determine appropriate compensation for privacy violations. It's about recognizing the real impact that privacy violations can have on our lives and ensuring that we're adequately compensated for those damages. Prevention is always better than cure. That's why education and awareness are key. Both medical providers and patients need to understand their rights and responsibilities when it comes to their privacy. They need to know that potential consequences of privacy breaches and how to prevent them from happening in the first place. And it's not just what we're doing here in Indiana. Other states have adopted a more nuanced approach, balancing the need for privacy protection with the legitimate interests of healthcare providers and other stakeholders. We can learn a lot from other states and jurisdictions with robust privacy protections in healthcare. By examining their approaches and identifying best practices, we can ensure that our laws are effective and up to date.
So there are multiple factors that come into play when it comes to what's considered private versus public. It's determined by how many story can reach or topic. There's no certain amount of people knowing the information for something to be considered private or public. It just depends on how the information is spread. Throughout the ZD versus community health case, it was made clear that people consider things public and left open for those of the public to inspect information and for things to be communicated throughout the public. Things must be communicated to come off as crude and offensive, to grab attention for those to have a need and want to know about the topic. A scenario with a healthcare facility and a patient being involved, the healthcare facility would have to publicly announce the patient's information, like up on a board or somewhere else, so it's made very clear of what is being spread. If a doctor tells the patient just the information individually and someone were to overhear, by accident walking in the hallway, that's not the doctor making an attempt to try to tell the person in the hallway. They just overhear, but it's not a public attempt.
For the plaintiff to qualify to receive compensation for damages regarding invasion of privacy, the plaintiff would have to prove that all four elements to sustain a public disclosure claim have occurred. Community's handling of the plaintiff's information does not satisfy all four elements of this claim and therefore should not be approved for compensation. It is undisputed in the court that ZD, the plaintiff, satisfies only three of the four elements. Number one, the information was private. Number two, the information was not of legitimate concern to the public. And number three, that the information released was highly offensive to the reasonable person. However, ZD's claim cannot be satisfied for the fourth element, that the information was communicated in a way that either reaches or is sure to reach the public in general or a large enough number of persons such that the matter is sure to become public knowledge. This claim fails because this act wasn't an intentional tort committed by community, meaning the release of information was not an intentional act committed by the hospital. Even if the public disclosure claim allows unintentional torts to be prosecuted, the modified impact rule bars any emotional distress damages to be claimed. Lastly, there is no genuine issue that the information disclosed was made to be public knowledge, as one person cannot be deemed the public. Community's unintended act was made to one person, and to be considered a violation of the public disclosure tort, there needs to be obvious proof of the public being made aware of this private information as a result of community's alleged actions. Community disclosing the information to one person does not equal the automatic disclosure of information to the public. Whether Kendrick decided to disclose the information to the public is not of the concern of community's responsibility. The direct communication of community to the mislabeled Kendrick's house is not to the public and would not have become public knowledge without Kendrick's own actions. Community negates the publicity element because the direct disclosure to one person is not actionable by law, as one person received the disclosed information, not the public. Kendrick's actions were not influenced or encouraged by community, and the liability of the information that was disclosed to more people should fall directly on who disclosed it. Kendrick not only acted out of her own volition, but acted out of malice to disclose ZD's private information and profit from community's unintentional mistake. Community's act of unintentionally disclosing information to one person does not qualify as disclosing information directly to the public and negates any responsibility for Kendrick's individual actions against ZD.
To summarize everything, after reviewing similar cases and articles that noted common malpractice cases across the nation, we feel like there should be emotional distress damage in normal negligence cases. Although prompting emotional distress damages to be suitable for normal negligence cases may serve as an extension for more cases to be filed with intentional profit of the consumer, this will ensure proper documentation and evaluation during any type of visit, while creating a secure outlet for patient-provider dialogue. Even though every medical practice isn't guilty of neglecting their consumers, a notable amount had been documented within the state of Indiana alone. Publishing to one person is not enough for liability and invasion of privacy cases, simply because it leaves room for bias, judgment, mistruthfulness, threats, and many distasteful gestures from both providers and consumers. The best argument that can potentially be proposed from the opposing view may be that HIPAA remains to be suitable for our healthcare system to utilize, but with technology advancing by the day, modifications need to be made to ensure the security of patient information. Changes need to be made to the current laws that are in place. We believe it is a necessity to strengthen the quality of care that is provided through our nation that is so costly to us.
Ladies and gentlemen, we have heard arguments and evidence regarding the unfortunate incident involving the unintentional disclosure of private health information. It is crucial to remember that this case is about more than just the facts presented. It is about understanding the complexities of maintaining patient privacy in today's healthcare environment and ensuring that justice is served. First and foremost, I want to emphasize that the disclosure in question was entirely unintentional. There is no evidence to suggest that the medical provider or its employees intended to disclose the patient's private health information to the unintended recipient. Instead, it was a regrettable mistake, compounded by the complexities of managing patient information in a technically advanced healthcare system. Upon discovering the error, the patient took prompt and proactive steps to mitigate potential harm. They contacted the intended recipient and negotiated the return of the letter containing the private health information. This demonstrates a genuine commitment to rectifying the situation and safeguarding patient privacy to the best of their ability. Furthermore, it is important to note that the disclosure did not result in widespread public exposure, while the unintended intended recipient posted the information on social media, the limited reach of the post does not meet the standard threshold for public disclosure claim. The medical provider's swift mitigation efforts help contain the impact of the disclosure and prevent further dissemination of private health information. In addition, the medical provider has demonstrated a strong commitment to compliance with healthcare regulations, including the HIPAA, Health Insurance Portability and Accountability Act. This institution has implemented robust privacy protocols, cybersecurity measures, and employee training programs to safeguard patient information and ensure legal compliance. Finally, there is a lack of clear evidence linking the unintentional disclosure to substantial damages. While emotional distress damages may be sought, it is essential to establish a proximate cause between the disclosure and the alleged damages. In this case, the damages claimed by the plaintiff are not directly tied to the disclosure, but involve other factors such as strained relationships. In conclusion, I urge you to consider the compelling facts presented in this case, the unintentional nature of disclosure, the provider's proactive mitigation efforts, limited public exposure, compliance with regulations, and lack of clear evidence of substantial damages collectively form a strong defense against the legal claims brought by the plaintiff. I ask you to weigh the evidence and render a verdict that reflects the truth and ensures justice for all parties involved. Thank you for your attention and careful consideration.